Hello, good evening, and thank you so much for coming to this Brennan Center for Justice event. I'm Sewell Chan. I'm the executive editor of the Columbia Journalism Review. More than 20 years ago, when I was a young reporter at the New York Times, when I joined the paper in 2004, I was assigned to cover the transportation beat. One of the very first people I met was Stephen M. Polan. Steve had served as the general counsel of the MTA for much of the 1980s and had played a big role in the rebuilding of our mass transit system, which may perhaps need some attention again. Steve was a public servant and a committed lawyer in the best of senses. His devotion to public and administrative law, to strengthening institutions, to serving the commuters and the people of this great city were really, really commendable. Now, I fell out of touch with Stephen, and he got back in touch, however, with me a couple of years ago when I was doing some nonprofit journalism in Texas. And I was delighted to hear from him, and Steve invited me to speak at a public policy forum at his second home in Crested Butte, Colorado. I accepted the invitation with much anticipation. Unfortunately, Steve passed away before I had the chance to reconnect with him in person. So I did go through the speaking engagement and had a chance to meet Steve's family, and I just really want to cherish his memory for a moment right now. So I'm very, very pleased to introduce this panel. And of course, starting on the left with Terrence Johnson, the Adams Professor of African American Religious Studies at Harvard Divinity School, and the recipient and current Stephen M. Polan Fellow in Constitutional Law and History at the Brennan Center. Please give him a hand. Next, we have Dr. Vincent L. Wimbush, the founding director at the Institute for Signifying Scriptures and a noted theologian. Please also give a hand to Kathleen Cavaney, the Libby Millennium Professor at Boston College Law School. And last but not least, my friend Corey Bretschneider, Professor of Political Science at Brown University. Tonight, in a very timely fashion, we're excited to explore the tension between religion and politics, law and culture, originalism, and the Bible. The people who drafted our Constitution and its amendments had varied understandings of religion, which influenced their views of governance, liberty, and equality, concepts that remain contested today. Today, when proponents of originalism argue that constitutional interpretation must follow its so-called original meaning, are they engaging with that nuance? And does the way we interpret the religious Bible influence the way we do or should interpret our secular Bible, the Constitution? So let's get started with some pretty simple questions. Terrence, as we begin, can you define originalism for us?
Sure. I'd like to first thank the Polan family just for their support for this great fellowship, and really try to frame, in part why we're here. After the Obergefell decision in 2015, I was really struck by Justice Roberts' notion of, who are we as citizens, as mere mortals, to think that we can actually change marriage that's been this one way, quote unquote, for millennia. And there was something about the way in which, as I read his dissent of Obergefell, that really spoke to me in terms of like this idea, wow, he's reading the law as if there's something inherently divine, that it's in some way a kind of scripture. And I wanted to figure out, is there a way to actually engage originalism by bringing in concepts that I knew very well around something called the talking book tradition within African American religion. And it's this notion that the talking book, that the Bible is a kind of dialogical text, a text that one engages right through conversation. But what's interesting is that it makes it different, say, from originalism or even from the living text, is this notion that you would engage the text with the attempt to actually expand the very possibilities, right, of who can engage and think about liberty, who actually is included in the conversation. So it's never about this idea of returning to history as a way to recall and then to, in some ways, relive what was recalled. It's this idea of how does one return to history, right, wrestle with tradition, wrestle with the existing debates, and then from that moment, imagine something new. And so as we think about originalism, which is clearly multifaceted, but the sort of the reigning belief that this idea that we want to understand the intent of the founders and the intent of the text and then apply that to modern society. And often the ways in which originalists have used it, it's been a way in terms of wanting to relive in order then to kind of foreclose any conversation about how do we even complicate our particular past. And the talking book tradition is this notion of let's actually look at the surrounding circumstances, right? The psychosocial dimensions of society to determine what's influencing the framers of the Constitution. And part of the argument is that we often say, well, the text is only written for a certain group of people. And I want to push back and say, along with other scholars, is that no, in fact, they were reading the Quran. They were very much aware of enslaved persons. They were very much aware of the contradictions, but they made a very specific decision in terms of we will, in some ways, exclude this conversation for the sake of a broader union and let others deal with it. And so I want to push back and say, we can't simply allow originalism in some ways to control the conversation. And I'm wondering, can we think of this idea of the text as a dialogical exchange that recognizes histories, acknowledges the circumstances, the very stories that we tell about the text, and then use those as a way to make interventions, but to engage contemporary debates. And I think all this sort of points back is the notion of the Bible, the Constitution, and the New Jerusalem, right, in terms of as the foundation of this sort of American exceptionalism, this American project that I want to argue is really fueling the conversation today. And I think today we're really trying to figure out how do we make, in some ways, interrogate this notion that the Constitution is a kind of secular Bible for the people.
Is the Constitution America's Bible for the other panelists, and what does it mean if it is? Starting with Professor Wimbush.
Yeah, well, first of all, thank you for inviting me to be part of this experience. I think the topic, as I approach it, as I think I understand what's at stake, what the anxiety, where the anxiety lies, and so forth. It's very important that we're all here, and I thank you for inviting me to be part of this discussion. Let me say a word about what I think I can bring to the conversation, to our thinking about the whole table of issues that I think is being set up tonight. And I think it may be important for me to say just a brief word about my own training and orientation and sensibilities that I want to advance here as part of a challenge to our thinking. I'm actually not technically a theologian. I'm not, but I don't want to be picky about that. What I want to suggest is that it is really important to think about safe space, protected space that allows one to raise certain kinds of questions, address certain kinds of problems, and to pursue them along certain lines. The theologian typically operates within pretty much, even if in a complicated way, a faith community and is responsible for handling the traditions of that community so as to advance formation. My training is actually sort of mixed in that way, and I've actually found myself as something of a stranger or an exile, if not a kind of intellectual maroon. And I think I can say this and relate it to our topic for the evening. The Institute for Signifying Scriptures is an initiative that was begun because along with some proteges, we found it very difficult to find the safe space to raise certain kinds of questions. For example, I think it's important to back up and ask the most basic and fundamental question that's likely behind most or all of the issues that we have in common. And I mean in this room, if not the entire polity, that's the United States. So my training and sensibilities and moments of exile would lead me to ask the question, not so much in the middle of the thing as in who started originalism and, what are the good or bad or mixed things about it, especially insofar as we want to compare that to or bring it forward in relationship to the concept of Bible, or my preferred term, Scripture. So my challenge is to ask us to ask ourselves first, arrogating to ourselves safe space to ask this kind of question, what is a sacred text, or what is Scripture, and what work do we make it do for us? Already those heavy questions suggest that it's a problem making the assumption that there's any kind of real thing in existence in the world, as in a real object, that there is a thing called Bible or Scripture or sacred texts, very problematic wording, in se or per se. So I just want to ask us to keep in mind how important it is to excavate or interrogate at the most basic level the terminology that's been handed to us. Because I think otherwise we reduce ourselves to fighting over the kind of strictures, the kind of formation. We actually fix ourselves thereby as theologians in different domains rather than critics assuming a kind of position, even if for the moment, even if for the sake of debate, a position of estrangement, so as to be able to pursue these questions. So I hope that can be part of the contribution that I could bring
Super
to
helpful
the conversation
framing.
tonight.
That's super helpful framing and so well put. I mean, it reminds me that when we use terms like the framer's intent, or history and the text, the history and the tradition, what do we mean by that? The very use of those phrases implies that the founders were coherent, cohesive, in agreement about what those terms mean, and we know from the history that they were not. And so I want to kind of pivot, and we'll come back to you, Vincent. I want to pivot to Corey. You've written about the uses of religion in the Trump administration. The current one, the second one, seems to have an even more explicitly kind of pro-Christian agenda. How does that, what is the Constitution's Establishment Clause, which, remember, that says the government shall not take part in establishing an official religion. How does that intersect with the agenda going on in this new Trump term?
I'll speak to that and to the general theme. I think what modern originalism does is it attempts to say that the text is a kind of sacred text. It is our law, and it has to be understood in a definitional or semantic way, and that informs decisions that seem to be really taking the side not of religion generally, but of Christianity in particular. I wanted to speak to the general theme too about sacredness, and to say that the answer is yes, I think, although the way the originalist does this is problematic, to say the least. That not only is it a sacred text, but that repeatedly, and you'll see how this remarks about history are relevant to the current moment, the reason why it's sacred is because we've faced constitutional threats from presidents throughout American history, and presidents have used their enormous power to threaten democracy, but the thing that has repeatedly saved us is the text. And specifically, it has been citizens willing to read that text for themselves in a democratic way, as opposed to the authoritarian way that American presidents and courts throughout American history have often read it. That's the thesis, anyway, of this book I've written, The Presidents and the People, 5 Leaders Who Have Threatened Democracy, and the Citizens Who Have Fought to Defend it. So I'll just say something about it, because I think when you see the citizen interpretation, it gets to the wider themes that we're talking about. In particular, the founding of the United States, George Washington said, I just took the oath, a sacred oath, to preserve, protect, and defend the Constitution. And if the people assembled here see me violate it, hold me to account, criticize me, upbraid me, even subject me to constitutional punishment. But so quickly in the second presidency, we go from that mode to an authoritarian one. John Adams signs the Sedition Act. It makes it a crime to criticize the President of the United States. It leaves it open legally to criticize the Vice President. Why would you do that? The Vice President at the time is Thomas Jefferson, a member of a different party, and the Sedition Act is used to prosecute 126 people we now know, a shutdown of speech. Now, how do we recover? It is the text. The citizens, including Thomas Cooper, say we have a right to free speech. It doesn't mean, as Adams says, a limited right that doesn't include the right to criticize the president. And they use their own trials to put Adams on trial, to defend the idea, not just of any text, but of a democratic lens to interpret the Constitution. And they don't prevail in court. Courts make things worse. Samuel Chase seeks the prosecution, he lobbies for the Sedition Act, but they use politics. They reclaim the Constitution by electing Jefferson, who says we're all Federalists, we're all Republicans, allows the Sedition Act to expire, pardons the editors. But America really learns how to interpret the Constitution by one constitutional hero. And that's the person, to my mind, that really teaches us the best answer to this question. That's Frederick Douglass. Douglass is living in a time, he predicts that Buchanan is lobbying the Supreme Court to deny all Black Americans all rights under the Constitution. And in the Dred Scott case. In the Dred Scott case, and using a fake textualism, as Douglass puts it, they do exactly that at the behest of Buchanan. How does Douglass respond? Most abolitionists say, and you could imagine an answer to our question that says this is a pact with the devil. That's what Lloyd Garrison says. But Douglass does something quite different. He says we have to read the text in the right way. So take its preamble. It doesn't say, we the white people. It says, we the people. It's a principle of democracy. Take the ban on the corruption of blood, the idea that you could inherit the crimes of parents in the next generation. Douglass says, we've done away with that. What is that but an abolition of slavery? And most importantly, he says, we have a Declaration of Independence. And what we need to do is read that as the lens, the demand for humanity's equality, the lens to understand American democracy. He prevails on Lincoln, who in Gettysburg comes to that view, although he's very far from it in the beginning of his term, and really in the Grant administration. So two last sentences, which is, I think that when we think of our current moment, that the text can offer a way forward, not by trusting courts to interpret it, but by using it for ourselves to resist authoritarianism.
Just to be playful for a moment, are the Reconstruction Amendments, which of course, especially the 14th, due process, equal protection of the laws, political, at least legal political equality for Black Americans, though not actual social and political equality until much later, are the Reconstruction Amendments kind of like a New Testament?
Well, in this sense, that Douglass is the person who believes all along. I guess it's not quite, because Douglass's argument is all along, if you read it in the right way, those principles are there. And he uses that phrase, equal protection, throughout the 1850s and even earlier. And so what I think those words do, at least from his lens, the one I'm applying, is they take the original meaning, the sacredness of the original meaning, and just make it explicit.
So Kathy, in both the Dobbs ruling, which overturned Roe versus Wade, and I believe, I'm not a scholar, the gun rights case, increasingly you see conservative justices referring to the original kind of history and meaning. Tell us a little bit about what that turn is doing. What role does tradition play, and what role should it play in constitutional interpretation versus biblical interpretation? And of course, as a professor of law and theology, you can answer.
I guess that's what I was going to try to set just a little, kind of frame it as as thinking about it as law and theology. So in this, the question is really, in what sense is the Constitution sacred scripture? If you think about both words in Latin, you get a little bit of a sense of where the problem is. So scripture, scribo, scribere, scripti, scriptus, means, or scripsi, scriptus, means to be written. It's written down. It's fixed, I'm sorry. And sacer is where the word sacred comes from. And this is a very strange word. It means sacred and holy, but it also means dedicated to God, often for destruction purposes, in sacrifice. There's a really difficult side of this, and there's a lesser meaning of this, but still prevalent: execrable, detestable, horrible, infamous, and criminal. That's one of the meanings of sacer. So what happens if we think about the Bible and the Constitution in terms of writing, scriptus, and in terms of sacer in all of its meanings? Well, I think there are just 3 points we can make that go to your point. First, like the Bible, different parts of the Constitution were written at different times. How do we relate the different pieces of writing? Now, scriptural tradition has faced this question. Constitutional interpretation, not so much in my view. Scriptural interpretation, one of the main ways it's done is sort of in the type-antitype model. So they read the Old Testament, the Jewish Hebrew Bible, as sort of prefiguring what has come to fulfillment in the New Testament. Sometimes you read certain portions as key. So, for example, in a lot of African-American biblical interpretation, the story of Exodus for liberation theologians is key, and that's the hermeneutical, the interpretive key for the whole thing. For others, it's the synoptic gospels, the story of what Jesus did. So my question there is, do we have a key for interpreting the Constitution? And I think we do. One is either the preamble, the other is the Declaration of Independence, and sometimes you talk about the second founding with the 13th, 14th, and 15th Amendment. So that's the first question. The second question we have to ask is about both texts, is how do we deal with texts of terror? And that's what a famous feminist theologian, Phyllis Tribble, talked about in terms of the passages from the scripture which talk about the demeaning of people or the derogation of women, of minority groups, of the stranger. How do you deal? Domination, yes. How do you deal with that? And do we have to trash the whole document? And as you pointed out, William Lloyd Garrison said that the Constitution was a covenant with death or an agreement with hell because of the way it did not address the slavery issue. Do we have to get rid of a document that has texts of terror? No, but we need to deal with it better.
Hey, Kathy, might I say, and also for many African Americans in terms of the talking book, it's this notion that you use it as a way for kind of an opening in society, an opening not only for conversation, but as a way to push back, and not simply to use it as parallel, but simply as a resource, as a starting point for interrogating the circumstances under which people have been enslaved. And it's not necessarily, right, a pathway, but it's simply an entry point, and to say you don't have to read it in this one way to affirm your tribal interest. And in fact, there is an alternative way, and it's simply a matter of how do you open up the conversation to highlight what has been in some ways ignored.
That goes to the third, I guess the question is, one of the questions biblical scholars who've looked at the interpretation of Scripture in America have asked is it our political leanings, is it our political views that's driving our biblical interpretation, or is it the biblical interpretation that's driving the political views? And the same thing can be said about constitutional interpretation. Are you an originalist or a textualist because you like the results, or do you get the results because you are adopting this particular method? So those are 3 questions that I think apply to the Bible and also apply to constitutional interpretation.
I'd like Terrence to get in here. What would the talk, let's rip from the headlines, birthright citizenship, right? The notion, the 14th Amendment states that all persons born in the United States are citizens. It also says all persons born in the U.S. and subject to the jurisdiction thereof. And that crucial clause is doing a lot of work now. People are saying, hey, hold on. This amendment was intended to help newly emancipated African Americans. It wasn't about illegal immigrants. It wasn't about the Chinese and the Mexicans who would come in. How would the living book, talking book tradition help us understand or think about this very modern day controversy?
Sure, I think it's a great question, and I'd love to hear everyone's kind of respond as well. But I think in some ways a talking book will say, look, how do we actually understand the ways in which the 14th Amendment was actually used in some ways to dictate culturally who was sort of seen as legitimate, meaning who was white, and who was actually the problem, meaning African Americans. Ariella Gross, a law professor at UCLA, argues that in many ways we have example after example in which the Supreme Court determined who was the problem based on racial constructions of whiteness, and that this was not something that we simply emerged, but in fact it was actually created. And in many of the early immigration cases, right, there are South Asians as well as East Asians who said, look, we want to prove that we actually are Aryan. There's a famous Indian case in which they said, look, we can trace our heritage back to the Aryan race. And so therefore, in order to vote in the country, since we know you can't vote as an African American, we want to tie ourselves to the white race. Yes. And the Supreme Court said, no way, because you don't have a history of voting, and therefore you are aligned with African Americans. I think, and that particular historical notion, I think, is really critical, in part because it shows the ways in which we have constructed, right, in some ways, these walls that now people then are forced to figure out, well, do I want to join this particular silo? And if power actually equates to a kind of performance of whiteness, as Ariella Gross talks about, then we see this huge division where immigrants are being forced to say, well, how do I become a citizen? Well, you perform it by showing that you are actually white and middle class.
Thanks. I think this is obviously an extremely important question, and I would say on it that here, everyone who is sensible in constitutional law agrees that this executive order is unconstitutional. In fact, I think the reason why it was proposed was to assert authoritarian power. The originalists, the people pursuing a kind of more moral reading along the Douglas lines, anyone who can read sees what it says, which is that if you're born in the United States, that you are a citizen. Now, the subject to jurisdiction language applied to ambassadors and at the time Native Americans who were not citizens of the United States. That changed in the 1920s. And it really is only John Eastman, the person who crafted the insurrection, that came up with this idea as a way of really asserting authoritarian power. So I think that's the thing to say about it, that here the decency of textualism comes through regardless of your idea of it. Yet that's not true of all the issues that we're going to face, that many of the modern originalists, when it comes to Trump's authoritarian power in usurping the spending clause, in destroying agencies like USAID, in the plethora of attempts to demand loyalty and fire against the law, every disloyal member of the more than 2 million people that make up the executive branch, those are the issues where the anemic authoritarian textualism will come up against the democratic version. And just a last sentence on this, we have to distinguish, I think, between what's happening, which goes beyond even that authoritarian textualism. It is a raw form of, well, a coup in the service of dictatorship. And even the worst form of textualism is better than that.
Vincent, and then I'll come back to Kathy. Vincent, you're an expert in biblical interpretation. Now, the Bible, of course, historically was used to try to justify slavery, imperialism, subjugation of women. When you hear legal scholars today wrestling over whether the Constitution includes a right to privacy, whether the Constitution says that people born here to undocumented immigrants are not citizens or are citizens, how do you see the parallels between the these two interpretive battles?
Yeah, so I see that what we're doing is comparing texts used primarily in two different domains. Both are constructions. Religion is pretty much a modern construction insofar as it's set up to be apart from other parts of society and culture. That's a fairly recent development in a long history of human beings. Textualism, I want to argue, is always and everywhere a problem, specifically a problem about violence. It aims to reduce, to limit, to simplify. The delimitation is clearly there, always pretty much concrete. Texts of terror, yes, in both domains, in terms of religious books that are used by a circle of folk who confess this or that, and the Constitution itself should be seen as texts of terror. The problem that I think we're still embroiled in is we think that we're going to liberate ourselves or anyone else through certain kinds of creative exegetical gymnastics. What we must do is address the most basic problem. Now, I mean, I'm not a direct student of Levi-Strauss, but I think it's worth going back to his challenge and saying that writing from the beginning was invented, always aimed to enact slavery. Now, you can play around with that so that the slavery actually represents not anything to do necessarily with physical or chattel slavery, but these operative exegetical gymnastics are always at play. If you think that you can be liberated by simply identifying texts that are problematic and somehow reduce yourself to making them palatable, you're already in trouble. The Constitution is an example of that as well. Therefore, I'm asking us to really deal with. I'm not saying it's going to be handled in the next 5 minutes, but I'm saying we need to stop running away from what the fundamental problem is. That it was from the beginning meant to be a text to exclude,
Totally,
and to reduce us to playing games.
I need to ask
within that formation.
Quick follow-up. How do you trace, though, the moral arc that brings us from, or the political arc that brings us from Thurgood Marshall to Clarence Thomas? Marshall believed that we could find in the text evidence for overturning Plessy, we could find in the 14th Amendment the tools we needed to overthrow legal segregation and subordination. Has that tradition kind of, is it out of favor?
I don't disagree with your interpretations of what Frederick Douglass sought to do. It didn't work. It's not, it didn't work in the sense that there's no winning in playing the game as he tried to play it, given the way the game was set up. Now, I simply want, it's a kind of critical studies approach to Scripture that you could compare to critical legal studies. And I'm saying the scriptural itself is intended to delimit and to qualify, and we need to aim at that projection. There is no thing that scripture in the world per se.
I want Terrence and then Kathy to respond.
Can I just finish this statement and I'll back off. So the point is, nobody can point to a thing called scripture in the world. It must be heavily qualified so that you're forced to get back to the problematic that has to do with social psychology and politics in the world. So the arguing over a specific text is actually a game we're forced to play in the various domains.
And ultimately losing one, perhaps.
Right?
Okay, quick responses to Vincent's provocation from Terrence and then Kathy.
I mean, just very quickly, I think Vincent is onto something, because Thurgood Marshall wrote in 1987 at the bicentennial, is like, look, I don't want to participate in this in part because we have fabricated a particular kind of past that we won't acknowledge. We can't have the celebration until we acknowledge, right, that these men were not smart and that they were not attempting to include me in this Constitution. And then once we can kind of interrogate that history, then we can rethink how do we actually, quote unquote, commemorate, or they use Toni Morrison, how do we remember the founding of and the framers of the Constitution?
We imagine what our 250th birthday next year looks like. Very quickly, Kathy responding, and then Corey.
Just a couple of quick points. I believe in the rule of law. I'm a lawyer, and I believe that the text is not something that is, going to settle every question, but I think it can provide a framework that's helpful for practical guidance. And I think writing it down gives us a place to start our conversation. It shouldn't end our conversation, but it's a place to start it. It's a focus of a communal activity, which includes interpreting the law itself.
So, Corey.
I love this conversation. I would say that, to me, the real heroes of American democracy, who are not judges, but are these citizens that I'm talking about, the newspaper editors who fought the Sedition Act, Frederick Douglass, the main hero of the American story, William Monroe Trotter, who fought back against Wilson's white nationalism, and Ida B. Wells, and more unknown people like Sadie Alexander, a member of the Truman Commission that really changed the course of civil rights in America, putting it on the agenda for Truman and Democrats after. And of course, Martin Luther King, the most famous constitutional interpreter. I think they were doing both, that they were certainly engaged, obviously, in politics. They weren't trying to just use legalism or the courts. They were prevailing on subsequent presidents, forming movements behind ideas. But, now here's my but, they used the text over and over again. And I would say, in each case, it didn't work permanently. It didn't work if we want a regime of pure democracy, which we are definitely not living in, but it worked in a period of recovery, again and again. And American democracy is a series of crises and recoveries, but the recoveries were real. The 1964 Civil Rights Act, the 1965 Voting Rights Act, the efforts of that long march did matter. So I would say both, that text matters, but it has to be combined, not just with politics, but with a political imagination.
I also think there are texts and there are texts, right? So for St. Thomas Aquinas, law is an ordinance of reason promulgated for the common good. So it isn't simply a text to be read abstractly, it's a text to be read in light of a purpose, which is the common good. So to interpret the text, you have to understand what the common good is. So we made a fundamental decision when we interpreted our Constitution. We decided it was basic law. We didn't put it in the realm of someplace else. We interpreted as law, and they use legal mechanisms in order to interpret it. And I think that's very important. It's a practical thing. It's not a theoretical thing.
But what if we start with this idea of the enslaved and those who have been left out, to say, well, actually the text has been used to interrogate, to repair, to reconcile, and possibly to transform. That's not about the common good. It's actually about rethinking the very orientation of what we might imagine as a common good.
Exactly, yeah. I mean, I don't think anybody has a clear understanding of what the common good is. I think that the way you think about the common good is actually as a gerund. It's common gooding. We figure out what it is while we're in the middle of it. And we saw this, this tremendous exclusion of all sorts of people, particularly African Americans, but also others.
Democracy is a verb. Yeah.
Yeah.
Well, it just seems to me well, first of all, Douglass et al. Responded the way they did because they found themselves within a formation, a scriptural civilization or a scripture formation. So we need not make of their responses something different from what it was. They were placed in a scriptural formation. In order to negotiate that scriptural formation, they became creative exegetes of a sort. Now, the reason that's important is because I'm trying to get us to demystify these categories. So the very notion of sacred text is, of course, somewhat idiotic. We take it for granted, but the juxtaposition of those two, it's really quite problematic. What I'm saying is that begs analysis. That means that we ought to come to terms with or try to understand textual politics as it evolved over a long period of time, and to see that what maybe was being interpreted was something on the other side of or behind the text that was never named or that was obscured for reasons that, history tries to make clear, and that's the kind of thing I'm arguing about. But so you need to be careful comparing and setting up an easy comparison between Constitution and Bible without interrogating or excavating the terms of the invention of both and the kinds of politics that are always involved in both of these.
We're moving to Q&A in a moment, but just a quick question. Sorry, as a journalist, I have to simplify and sometimes oversimplify often. The Warren Court era, NAACP Legal Defense Fund, bringing cases to the Supreme Court, expand rights, find rights that are in the Constitution, privacy, etc. An era of kind of liberal movement forward. We're in the Roberts Court now. We're 20 years in to the Roberts Court. What do you say, each of you, to young people who say the Constitution, yeah, we know it's not sacred. We know it's not sacred because it builds in the Senate and the Electoral College, and because there's nothing to say, and because it's been used to justify unlimited campaign spending, because it says nothing about social rights, freedom from fear, freedom to have housing and health care. I think a lot of young people are like, oh yeah, we get that it's not a sacred text. What do you say to that young person right now? Terrence.
Wow, it's a tough question. I mean, I would say that in order to, I think, rethink the terms of what we've inherited, you have to understand that particular history. Otherwise, there's a fear that we're going to recreate something that's even more powerful and particularly more destructive. I would also say that their criticism is partly correct, right? That the law has been insufficient, right? We think about Brown versus Board of Education. In some ways, it created more segregation, right? It led to the flight to the suburbs. It led to this idea of your zip codes became a kind of signifier for your life expectancy. So they are correct. And yet without understanding that history, right, in terms of what were the very conditions, right, that created oppression, that created a kind of, say, flourishing for the suburbs, without engaging that kind of tension, we're going to repeat the same mistake even as we attempt to disregard the Constitution. So I think the talking book allows us to, again, to return, to kind of reclaim and to kind of, reconstitute who we are. But you have to have that historical sort of starting point and sort of the critical analysis that, right, we want to become more of a kind of special sacred place by interrogating and thinking about ourselves in terms of the ongoing process of becoming a truer self in the Du Boisian sense.
Then Corey.
I think that we need to demystify what it is to make good law and to fight for justice while still maintaining that it's possible, and that law, including written law, has a place to play in that. People sign contracts. Who gets to sign a contract? Who gets to enforce it? All of those questions are very, very practical, nitty-gritty questions that the civil rights movement, that the movement to advance the rights of women, they fought on a very practical level. They weren't fighting on a theoretical level. They were fighting for equal pay for equal work. They were fighting for no redlining. They were fighting for very concrete instantiations of justice. And it's not glamorous, and it's not pretty, and it doesn't involve hermeneutics. It involves being in the trenches, and that's where the change is made all the way across the board, I think.
We're back, I think, in the question that you asked of should we abandon the Constitution. We talked about the play, What the Constitution Means to Me, which is about this question, a great play that I recommend. We are back to the moment of Garrison versus Douglas, and how should we reform America? How should we save democracy? One answer is throw it all out, throw the words out, and begin again. That's the Garrisonian way. The way I'm suggesting that we read the Constitution, again, is Douglas's way, and it's important that for him. It's not an exact analogy with biblical knowledge. It doesn't give us access to God, but the analogy is that there is a fundamental law, and that law is understood as the fundamental principles of democracy. And I would add that one of the most important victories of Douglas is that his words, equal protection, get enshrined into the text of the 14th Amendment. They're not just a part of the Constitution, to be distinguished from others. They're the lens by which we have to read the entire document now. It affirms, Douglas won that battle. And the fact that we got a 13th Amendment ending not just slavery, but the badges and incidents of slavery, a 14th, the equal protection idea, and the 15th Amendment, a non-discrimination and the right to vote, at least in regard to race. Those are Douglas's victory. And so I would say it's not access to the divine, but it is access to the sacredness of American democracy.
Okay, we got some spicy questions from our audience. Our Supreme Court, I believe, has a sixth, six of the justices are Catholic, at least six. Is it 6 or 7?
6-ish. Gorsuch was raised.
That's right. That's right. I love that. 6-ish. Should we be constitutional Protestants? I want to understand, however you interpret that, maybe Kathy and Corey on that.
I don't know what it would mean to be a constitutional Protestant. What I find very interesting about many of the Catholics who are on the Supreme Court is that their methods of constitutional interpretation bear more resemblance to a Protestant approach to constitutional interpretation, focusing on the text per se, maybe a little bit of the history, not focusing so much on the role of the text in light of the life of the country. So I think we do have constitutional Protestants, and then some of them are Catholic.
I'm going to take the question literally because I think it is important for the entire framing discussion. The Establishment Clause of the United States Constitution bars the establishment of an official religion, but it does more than that. It bars laws respecting an establishment or related to. And in my view, what that means is, despite the analogy with the sacred, you cannot, and this is core to our idea, reason in terms of one religion. So we can't have a Protestant or a Catholic constitution. We have to have one that is reasoned along the dimensions of the principles of the text and of democracy, and that protects religious pluralism. So that might have seemed like an obvious idea for a long time, but I think part of what's happened with this court in the prioritizing of rights, specifically of Christians over other fundamental rights, including gay rights, for instance, and that's a trend that you're seeing, and their deliberate evisceration of that clause that I just mentioned, allowing public displays of crosses and really eviscerating the jurisprudence and prayer in government meetings, eviscerating that idea. And that is a founding principle of James Madison in the Memorial of Remonstrance. It was the core, in many ways, of religious freedom, more important than the Free Exercise Clause. So I think we can't have a Protestant or a Christian or a Jewish constitution. We have one of religious pluralism. That's the idea.
Now, next question. Terrence, during the 3 years I lived in Texas, and I just moved back to New York a few months ago, I interviewed a lot of folks who felt a sense of loss. Now, you could say a sense of loss of domination, but you could also talk about it as a loss of a sense that we're a Christian nation. Church going in America has gone down, a trend that was accelerated by COVID. How do you respond to this sense of loss and decline that so many are feeling, and not just white evangelicals?
Sure. I think one way to look at it is, in some ways, oh man, to really imagine, to what extent, right, have we as a culture, both in terms of religious institutions as well as higher education, for example, how have we tried to mediate cultural, religious, and racial change in our country? I think in far too many instances, we've allowed one institution, for example, higher education, to kind of control and mediate that conversation. And I don't think we've had a public conversation in terms of, well, what does it actually mean to live in a racially integrated society? What does it actually mean? Now all of a sudden we are publicly talking about this idea of transgendered communities. What does that look like? How do we actually come up with new labels, new categories to understand, well, why is this conversation dominating this moment in our history? we've never really come to terms with this idea, well, how do we see Jewish Americans and why do they feel as if they are the perennial other? So there's so many ways in which this loss is so universal, and yet we have these liberal rights, but not the cultural conditions to actually facilitate a conversation in terms of what does it mean then that we once said these people, African Americans, were ignorant and were the very the butt of the nation's sort of problems, and yet now we're telling people, oh no, they're normal, they're like us, and gays, they're like us too.
I think we're at a point, I mean, and this is a frightening point in American history in many ways, but one in which we've really reversed the idea of religious freedom, because the original idea, as I said, is this idea of non-establishment of religion, and including laws and displays and public arguments even that...
No Church of England.
Yeah, no Church of England, or that relate to that idea. And yet the idea of free exercise that we've built up so much has become so extreme that it includes the right to really use Christian imagery, reasoning, the idea of a Christian nation to define the coercive apparatus of the state. And what that is, we have to call it by its name. It's not American democracy, it's not American constitutionalism, it is theocracy. And I think that is the desire in the extreme sense of wanting Christianity to play a role in public life.
Let me be a devil's advocate. What do you say to the person who said, all I was saying is I didn't want to bake a cake or make a website for the same-sex couple. I'm not being authoritarian. I'm just...
I think that that's part of the problem, right? I mean, first off, I mean, I think I'm not as sure that I would place the Establishment Clause and, you know, in the same high place over the Free Exercise Clause that you would. I probably would read them a little bit more, you know, in a more nuanced way, partly because of course, neither of those clauses applied to the states at the beginning. They only began to apply to the states in the 20th century. It was the federal government that couldn't establish religion. It was the federal government, not the state governments. I'm afraid we're going back in that direction. But I think the problem with the Establishment Clauses, the Church of Texas, is I think there's a real fear among some religious believers that there is no neutral common morality. Our fights today aren't about, you know, whether you have to be a member of the Church of England in order to be the, you know, governor of Pennsylvania. The fights are about, you know, same-sex marriage, the fights trans issues, you know, the role of women and men in the church. We don't have a common morality. So part of the problem with the Establishment Clause is I think some of these more conservative Christians and other people believe there is no neutral space. They believe it's against them and it's sort of rigged. So if you don't have a common area that you think is on common ground, you try to grab all the area you can.
But have we ever had a common ground, or is that simply a kind of bad faith? In other words, do they really, you think they really believe that? Or do they really actually believe something else, that we have lost something that's actually very tangible, that we can point to say those other people who are not like us, who are inferior, actually have our place?
Oh boy.
On the cake case, I wanted to respond. I mean, I do think the idea of the Establishment Clause is found in both Locke's Letter and Toleration and in Madison's Memorial and Remonstrance. And there the idea is a kind of public reasoning, that there is a common reasoning that's appropriate to the state, and that we can't have solely Christian, for instance, reasons for our laws. We have to back them in a plurality of reasons. Now, not everyone agreed with Madison, and there's the Clarence Thomas version that would allow state establishments of religion, the opposite of what I'm saying, a very thin one. But this is, I think, a fundamental idea in democracy of religious pluralism. So to take the cake case and to really get detailed, I mean, what the court says there is that the reason for denying the exemption to this person who wants to bake the cake is based in animus. Okay, so what is the animus that supposedly animated the Colorado Commission's decision to not allow an exemption to this baker? That's the accusation in the case, the way that it was decided. It was that the commissioners talked about tolerance. and that they talked about the fact that an intolerant form of Christianity didn't have a place in making laws. Now, the court found that to be animus towards Christianity, but to me, it is actually the definition of what the Establishment Clause is about. They were giving voice to Madison's idea. So we really, I mean, that theocracy idea, it's not theocracy in the sense that we have one religious priest controlling everything, but it's theocracy in our reasoning.
But I want to stay on this for a moment. There's, in a lot of these constitutional debates, there's a sense from the conservatives, from the right, that Christians are now an embattled minority in America. How do you respond to that?
How do I respond to it? Well, I think this is part of the, part of what is going on, because they, it was true that, they didn't want an established religion, but they were very, very clear, Locke included, that Christianity produced part of the common morality, Protestant Christianity, that was the basis for the whole law. That came up through Blackstone, that came up through the whole common law tradition. So there was a basis in Christian morality, Protestant Christian morality, for kind of the laws that were on the books, laws against sodomy, laws against adultery, laws against fornication, pretty much laws against, anything of that sort. So what they think is that there is being replaced this sort of, biblical Christian understanding of what morality is with something that's rooted in a kind of secular liberalism that's more choice-based, and they don't believe that's neutral at all, or that that's required by the Constitution, because Locke didn't write the Constitution either.
Go ahead, Vincent.
Yeah, I actually want to just raise the question whether, in terms of history of religion and culture in the United States, but this could be extended throughout the West, Western Christendom more generally, whether the conservatives are the ones who've actually moved or changed in any way, rather than the other way around. That is to say, it seems to me that what we're confronted with throughout history is a kind of wizardry that's textual, exegetical, that actually leaves the conservatives in a position of being kind of belated. That is, they've not figured out the latest sort of exegetical trick with all of this, because I agree with what I think I heard Terence said earlier, at least in questioning the idea that there ever was a moment of a certain kind of neutrality about any of this. What we're actually talking about is the establishment or the center or the dominant changing. And I think, that's where we're thinking about again and again and thinking through. One example that I would use, you all will recall Trump's trick with the Bible in front of the church in D.C. Well, whatever. Now, that was a gesture that was welcomed by conservatives or evangelicals and the like. Now, what's fascinating to me about all of this is that the gesture itself seems truer to the history of the West and the United States in general than whatever is the opposite. In other words, his performance actually displayed a truth about how these matters have been handled in history. And that is the thing that's unforgivable, because that in fact shows the history of the uses of the text in society and culture. And see, that's the problem, and he's figured that out. Perhaps he's certainly performing it very, very well, very, very well. And I think that means that our orientation about these sort of things, in addition to the kind of legal scholarship that I think you all represent, should also focus on the kind of history of the establishment of a certain kind of psychologics around these sorts of things, formation issues that are tied to these things. Textualism is really quite wily. At base, it's quite conservative, but of course it retains the power to move and maneuver quite quickly in order to protect dominance. And that's what needs to be followed. That's what needs to be excavated.
I want to get a final audience question, and I'm going to aim it at Terrence. If the Constitution is our Bible, is the judiciary our priesthood? And what are both the possibilities and limitations of that analogy?
Well, I mean, I'd have to really, in some ways, follow Vincent's thinking and just argue that, I mean, it really is bad faith to see the judiciary as a kind of sort of priesthood, in which, in some ways, our beloved John Rawls wanted us to imagine, right? And in some ways, see it as sort of a kind of meta place, sort of above history. And in that ideal thinking, in a very abstract way, I understand why one would want to imagine the Supreme Court as this ideal place, but history tells us it's something else. And in fact, in some ways, many people like Sanford Levinson have argued that in many respects, it's the Supreme Court that's held us back and reconstituted a kind of anti-blackness, a kind of, anti-Semitism, it's anti-Zionist kind of rhetoric. And so I don't want to get rid of that analogy in some ways and then point back to my friend Corey and say, look, let's look at the ways in which citizens have, asserted themselves, and then how's that assertion then pointing back to groups who are trying to mobilize around this notion of, can we actually sort of make the Constitution better? Can we actually make this union stronger through criticism, through a kind of interrogation that becomes, in some ways, kind of normalized, realizing that we're not going to get to the end point, but that part of the process of what democracy involves is the constant questioning and the constant kind of interrogation.
Now, Vincent, is that possible in a society that's not always the most scripturally literate, historically literate, or civically literate? Like, in other words, if we don't, is the kind of analysis that Terrence is talking about possible for the average person, given the state of how often poorly Americans understand our history?
Well, the literacy thing, the problem lies not in knowledge about or ignorance of the content of texts. The problem lies in our not following the psychologics, the power dynamics, the pathologics of textualism. I often use the term, actually, scripturalization in order to point to or describe the regime, which includes the two different domains that we're supposed to be covering here. I think it's mainly on the legal side, but this certainly would hold for religion. I would put higher education there and the way in which it functions as a kind of judge and jury in setting up a kind of canon within different kinds of disciplines and fields that function much along the same lines. So literacy in terms of getting at the content of the text, fine, that's basic. At a certain point, what ought to define critical higher education is asking the question, but what work are we doing? What magic is being displayed?
As opposed to just fetishizing what's happening.
Absolutely. And the fetishization is what defines scripturalization in the world in these different domains. That's what they have in common from my perspective. And so we need a kind of critical investigation or excavation that goes at these issues as well. And I think it would take us far beyond arguing. When we argue whether or not originalism is good or bad, it touches on it, but it doesn't go far enough. It's not that they're wrong, that they've read a text wrongly. It's about the politics of using text. Trump understood the politics of using the text. I mean, it looks boorish. It's very far from a high church tradition, but that high church tradition was simply masquerading that very usage of the text for centuries.
Sacred icon, right.
Exactly.
Some final thoughts now from Kathy, Corey, Terrence.
I said that one of the big questions is whether your approach to textual interpretation of the Constitution is driven by your politics or whether your politics drives your approach to textual interpretation. What should be done now? Well, think about what the people who are running things did. They spent 30 years, the Federalist Society, training law students, proposing, defending, articulating a particular theory of constitutional interpretation that had certain hooks to the broader community. We're just going to read the plain text. We're not going to impose judge-made law. And so I think the people who disagree with this approach also need to take the long haul and think about the power dynamics of having your approach to the text be the dominant one. So that's one of the things I think you need to do.
I would say that we're in a dire moment, and a lot of people are worried that there is no hope of recovery from this moment, but I think there is. That's what I've been trying to argue. On the literacy point, I think there's much more literacy now, of course, than there was in the 18th or the 19th century. Frederick Douglass would have been regarded as a crime to even seek to read, and yet he becomes, as I've been arguing, our most important constitutional interpreter. So I think when you look at the past interpreters, not the judges, and of course I agree with full force with what Terrence says, the judiciary is not the priesthood of the sacred text, we want to use that analogy of the Constitution. The thing that makes it defensible as an idea in democracy is that we all can read it. Not everyone has to read it. It was small groups of activists, what I call democratic constitutional constituency, who read it in a democratic way to reclaim it from authoritarianism, and then did use their political imagination, did use politics, not cases, to prevail on recovery presidents. So Madison in the War of 1812 doesn't shut down dissent because of the victory of these editors. Lincoln in Gettysburg comes around to the most famous idea of a sacred battlefield based on the notion of government of, by, and for the people. And Truman even realizes at the behest of the NAACP and their reading of the text of the 14th Amendment of the Equal Protection Clause that he cannot continue to be a segregationist as the people who have fought in World War II are being beaten on buses, on Greyhound buses, and in the streets, and comes to realize through their arguments about the text, way before Brown, that America needs a recovery. So we've been here before in as dire circumstances. It looked bleak. William Monroe Trotter, I mentioned, unfortunately kills himself thinking that Woodrow Wilson has spread white supremacy so successfully around the nation that we'll never recover from it. So those
at the height of Jim Crow.
At the height of, and the recovery possibilities seemed impossible at a lot of these moments, and yet they did happen and they were real, and that's what we have to do again.
Vincent, please, and then Terrence will have the final word. Some final thoughts.
Final thoughts. Renfield, in the novel, late 19th century, in the movie that came out in the 1930s, in a scene in which he's caught, he overhears Dr. Seward talking to others about how to go after Dracula. Renfield finally says, "Isn't this a strange conversation for men who aren't crazy?" The point, I think, that's made there is that if you don't address the most basic, the most fundamental question about what is real, you stay within a circle in which you're reduced to wrestling over at the textual, lexical level. The real is the meta-textual, the meta-lexical. That's what ultimately determines who we are, how we're differently positioned in the world. It must remain a challenge going forward if we're going to live in a different polity. The textual politics cannot remain the same. That is to say, reduced to arguing about who has the most creative, sexiest turn in terms of the content interpretation of text.
Thank you. Terrence.
You know, my late grandmother, Mary Kay Johnson, was a sharecropper from Alabama and moved her family up north in the 1940s. And what I always found really interesting is that, you know, at various dinners, you know, she would always talk about, you know, so her past, but also talk about issues around social justice and in very subtle ways in terms of, you know, reminding us there's a respectable way for us to behave. And she would also think about the ways in which, you know, Christianity was really complicated. She would talk about, you know, her grandfather who was a seer and who in some respects, you know, would tell fortunes to people. Most of his clients happened to be white. And I always found it interesting that she defined herself as this real Christian. She was Jesus-oriented and yet always understood that there were other practices, right, that didn't necessarily mean that they were contradictory. And so I mentioned this story in part to say that we're always telling each other stories that in some ways complicate how we see religion, how we see law. And I'm not sure we need a high literacy to understand the Constitution, but I wonder, how do we begin to take these stories that we tell at our dinner table, right, at our family gatherings, and use that as a way to recognize that people are always interrogating the world around them. The issue becomes, do we use these stories to reify our kind of tribalism? And is it possible to study groups who have used these stories to remember and not necessarily to dominate? And the question becomes, then why do some people choose to take these texts and stories to dominate and oppress, and others say, well, I actually want to use the stories as an entry point? And again, not to necessarily pit them against each other, but so another way to say it is, is to recognize that we are all kind of dealing with the messiness of our lives. And now we have to take that messiness and figure out, how then do we deal with that in a public sense, in a private sense? And I think part of this conversation was about recognizing that it's all messy, and yet there is a kind of power dynamic that we have to acknowledge if we actually want to achieve something that we call democracy.
Terrence Johnson, Vincent Wimbush, Kathleen Cavaney, and Corey Brettschneider, thank you. Thank you. Thank you. Thank you as well to our audience for your outstanding questions. I'm Sewell Chan. You can stay up to date on key issues of impacting our democracy with weekly analysis and insight from Brennan Center experts by signing up for the briefing newsletter at brennancenter.org, and be sure to RSVP for all our upcoming online public events. Thank you all for coming and supporting the work of the Brennan Center for Justice.